morning, everyone, and welcome to today's webinar, Avoiding Negligence Claims and Client Complaints. My name is Stephen Smith. I'm the Country Manager at Stewart Title, and once again, I'm delighted to be joined again this morning by Ian Quayle, who will be leading today's session. I think you're all familiar with Ian by now, so I won't introduce him as such, but good morning, Ian, and welcome.
Morning, Steve.
Ian,
I hope you're...
how are you feeling about the news overnight about the housing market? That's got to be positive, I think.
Well, it's certainly positive. The interesting thing will be to see just how the market reacts and what happens. Obviously, there's pipeline business and the valve is open, so there's work to do. But as I think we were discussing earlier today, the interesting thing is, will there be much of an appetite for people to put property on the market so that that sort of pipeline continues? I'm not so sure about that, given one, the problem relating to health issues and distancing. Just because we're relaxing a little bit, issues associated with distancing and concerns about health are still very prevalent. And I think the other thing is the economy. It's interesting to see what's going to happen with property values. It's interesting to see, given the fact that what a lot of people are saying is that, there are redundancies and there is a recession sort of looming. Are people going to be keen as mustard to go buy up market or downsize or whatever? I don't know. Obviously, as we've said in the past, there's a level of business that's always going to sit there. There will be clients that no matter what are quite happy to move. There'll be people that have to move. And as far as investment is concerned, I think this is the really interesting thing. I see investors seeing an opportunity, one, on the basis that property prices are falling, two, on the basis that there are sellers that are now keen to sell, but perhaps buyers that are reluctant to buy, and therefore a change in the market with regard to values that gives investors an opportunity. And the other thing is, again, and I think this is sort of a general comment, where there's uncertainty, rather than buying, people are perhaps going to be more willing to rent and just see what happens in the next few years, which again, I think pushes me towards investors being particularly active. So interesting times, Steve. Of course, working from home, as a lot of people will still be, generates issues with regard to ability to source information, etc. I suppose working from home now and knowing that, for example, that searches, etc., might be sort of flowing a little more freely will be a bit more comforting for conveyancers. But yeah, we're going to have to just, in short, the coward's route, we're going to have to just sit back and see what happens. But, far happier than I was, but still very reluctant to open the champagne and to say happy days are here again, because I don't think they are.
Yeah, no, I think I'm inclined to agree with that assessment. I think I suspect we might see a bit of a short-term spike as people, there's a relief and the need to bring some of the industry back and get it moving, but then perhaps some cautious realism setting in, I think, because as the scientists and the government have said all along, we're probably only at the kind of the start or the middle of this. It's a bit early, but actually I'd quite like to open this up to the floor today, that sort of change in the way we maybe start these webinars, and get everyone else's opinion. Obviously, it's hard to get everyone's opinion at one time, so we'll run a poll. It's a bit of there aren't infinite options to the poll, but I'll put this live now for you all to give a bit of feedback on your own view on it. So, the question is, following the government's advice regarding the reopening of the housing market, you expect transactions to reach pre-lockdown levels, and then we have within the next 3 months, in the next 6 months, in the next 12 months, in more than 12 months, or never. So I'll leave that up for 30 seconds or so, just for you to give your opinion on that, and we'll see what the answers is. Maybe Ian, you could give a bit of comment as to the answers as they come in.
Great, it's a great idea, Steve. To be honest with you, I'm really interested to see what people's views are out there. And again, I suppose the view might hinge on the sort of work that you're doing and the sort of clients that you've got. So, if you've got a lot of sort of elderly clients, I think they're going to be just as scared today as they were last week, and still concerned about shielding, etc. So, I think as far as the conveyancing market is concerned, forget it from them. But if you're doing a lot of investor work, then my view would be that perhaps you're going to be happy that levels are going to resume fairly quickly with regard to the sort of work that you're doing. So really interesting. So we've got the results in, Steve.
The results are in there. Obviously, we're seeing this live for the first time. I think what's good is there's a lot really in that kind of middle 6 to 12 months. Thankfully, people aren't pessimistic enough to say never. There's maybe 1%, but me. Also. Yes, indeed, yeah. But also not suggesting that it's going to come back instantly either. I mean, I think that's not too dissimilar to what I was thinking. Any thoughts yourself?
Yeah, no, I think it's a fair reflection, isn't it? The interesting thing is, Steve, and again, I'm blowing your trumpet here, that you've been during the sort of the gloom and the doom of lockdown at its worst, available and open for business. And you still are. So I know that you've got the resources available, so that if we're bombarded with activity and therefore bombarded with need for defective title insurance, that you've got the resources available to be able to meet that demand. You've got the flexibility to do so, which is great. And I'm sure a lot of firms have as well, which is good news. In the last recession, the thing that sort of staggered me was, in the land registry is the prime example, they sort of got rid of loads of staff, and then when the boom times came, they were sort of caught out on the basis that they didn't have the facility, and some would argue still don't have the facility to provide for the needs of conveyancers. But then that's me bleating about the land registry again, so let's leave that for a moment.
Okay. Indeed, yes. Ian, just before I pass over to you, just as per usual, I'll just go through the dashboard very quickly. I think most people that have been on the webinars now a few times will be familiar with it, and I'm sure you've used GoToWebinar in other circumstances as well. You are listening through your computer speaker system by default, and you can switch that to telephone if you wish. That's in the audio pane, and the dial-in information will be displayed. For those dialing in from the UK, that's a toll-free number. As per usual, you will have the opportunity to submit text questions to Ian and myself and Robert, who's also on the line, in the questions pane of the control panel. As I said before, you can submit the question at any time, but we tend to do a Q&A session towards the end of the presentation. You can also raise your hand if you're having any trouble, and also if you want to ask a question over your microphone directly to us at the end, we'll be happy to do that. Just one final thing I want to say, in your control panel there should be a handout there for you today for you to follow the notes from the session as we go along today. Yes, in order to download that, I don't want to teach people how to suck eggs here. I'm sure quite straightforward. Most of you, if you click on the handout itself, that will start to download. It will appear on the bottom left-hand side, I imagine, of your screen, and then you can click and open it or save it from there. So I think that's everything I wanted to cover. Ian, without further ado, I'll pass it over to you. I've noticed, Ian, I think your screen is actually on your GoToWebinar screen rather than the presentation. But, yes.
Yeah. Brilliant. Okay, Steve.
Thank you, Ian.
Lovely. Well, thank you, Steve. And good morning, everyone, and thanks for coming along. This is the fourth of the webinars in the first series. Just to let you know again that Stewart Title have agreed that we should, given the popularity of these events, organise a further 4, and more details of that will follow. And also, again, given that there appears to be demand for sort of in-house training events, etc., that Stewart Title will be contacting you in that connection as well. What I'm going to do today is scamper through some issues relating to complaints, client complaints, and negligence claims. I advise and have advised over the years professional indemnity insurers in connection with claims against conveyancers, looking at what a reasonable conveyancer would or wouldn't do. And I've also done training with organisations such as the Legal Ombudsman and looking at issues relating to client complaints. And I was fortunate enough to do some training with one of the largest conveyancing factories, and for a number of years was looking at their statistics relating to client complaints and what clients were complaining about. Quite an interesting exercise. So what I want to do today is quite simply heighten awareness, just show you where problems are arising, show you what can be done to avoid those problems, and just given the fact that we are proceeding towards a form of normality, just to look at where things can go tragically wrong and to try and prevent that happening. Before I sort of embark on going through the notes and the slides, there is a good book written by John DeWall. I've mentioned this before, sort of edited by a barrister called John DeWall QC, published by the Law Society, involving negligence in conveyancing transactions. It's worth a look at if you haven't already seen it. On slide, I also mentioned some other websites. All of these are free to access. The PLA website I like because a number of barristers provide papers and opinions that are free to access. City of London Land Law Committee's site, very useful, some useful precedents there. We talked about the variation agreement in lockdown, available on that site. Property protocols I've spoken to you about in the past and mentioned their boundary dispute protocol. The RICS website, I mentioned about the Consumer Guide to Surveys and Valuations. If you haven't seen it already, please have a look at it. A lot of firms provide it to clients on the basis that it sets out the choices that are available to clients and disadvantages associated with some types of valuation, etc. The Leasehold Advisory Service has come in for criticism over recent years about it being political. And I suppose to an extent it could be viewed as being landlord driven, but there's a wealth of material sitting there that's free to access and very useful. I mentioned in the past the fact that there is a guide about do you know your lease, and there's a consumer guide to leasehold property ownership. In addition to that, there's a calculator in connection with lease extensions. It's a bit rough and ready, but it's a useful guide. And there's a wealth of material on the Leasehold Advisory Service about challenging service charge, about challenging administration fees. And particularly in the light of the sort of government and land registry recommendations, land registry, Law Society and SRA recommendations about the potential disadvantages of leasehold ownership, some of the material in the Leasehold Advisory Service website gives the client a flavour of some of the problems associated with leasehold ownership, supporting what you're telling clients in connection with the potential dangers of leasehold ownership. A site that you're probably not aware of, ARMA, the Association of Residential Managing Agents, it has a code of conduct relating to service charge in residential leases, which is quite interesting, and also has another booklet about owning leasehold property, which again is very sort of client or consumer friendly and worth looking at and providing to clients. A site that I've just recently discovered last year, the Leasehold Knowledge Partnership, probably tenant driven as opposed to the Leasehold Advisory Service. If I'm going to maintain that sort of landlord driven, I think the Leasehold Knowledge Partnership redresses the balance. And I use this as an early warning system. If I'm dealing with landlords out of area, the Leasehold Knowledge Partnership will often flag up landlords that have been, let's put it this way, difficult, and provisions that they've got in connection with their leases that warrant or justify caution. And therefore, if you're dealing with, I don't know, a leasehold development out of area, so you're based in London and your client's buying a leasehold property in Cardiff, if you look at the Leasehold Knowledge Partnership, it might just flag up certain developers in South Wales that have had issues or problems that have been ventilated before the Residential Property Tribunal, and will highlight what the decisions of the tribunal have been, and will also highlight in more general terms certain problems that people have encountered with regard to a particular form of lease, etc. So that's worth looking at. The Legal Ombudsman site I like, and the reason I like it is that it explains how to deal with client complaints. And I like it for two reasons. One, there's some very practical information sitting there that's quite useful. And secondly, I'm a great believer in using the materials that the Legal Ombudsman generates for us in case we do have a complaint from a client and that ultimately the matter is referred to the Ombudsman. If we can show that we've done that which the Ombudsman requires us to do or recommends us to do, then surely that stands us in good stead. On the issue of client complaints, last year I was doing some in-house training with a firm, and they showed me a file relating to a client complaint. And this was someone that was very aggrieved about the conveyancing transaction, and justifiably so in my opinion. But the file had gone from a relatively junior fee earner to a relatively senior fee earner, to a head of the conveyancing team, to the complaints partner, to the senior partner of the firm. And the complaint file was an epic. It was, took a great deal of reading. And in essence, when going through the file, the file was littered with the client threatening the firm with a report to the SRA. And the senior partner said to me, "What do I do with this woman? If I say we won't act for you anymore, then that's just going to add fuel to the flame. What would your advice be?" And what I suggested is that the firm reported themselves to the SRA and said to the client, "Look, you've made all of these complaints about it. You haven't complained to the SRA yet, but clearly you're mindful of doing so. In order to resolve the matter, we're going to do it, and let's see what the SRA had to say." That sometimes is a way of sort of dealing with things. The Ombudsman's site and the recommendations and advice from the Ombudsman's site are very useful in dealing with client complaints. The thrust of what they're saying in essence is, don't let the complaining process become another complaint. And I think that's a great ethos, and there's lots of information on the Ombudsman site dealing with that point. The final site that I mention is a site you will be familiar with, but not in this context. Freestone Buildings is a set of barristers' chambers in town. There's a barrister there, a guy called Alan Tunkel, Tunkel, who many years ago devised what he described as a co-ownership questionnaire. And this is useful with regard to co-ownership in residential conveyancing, because the questionnaire highlights or extracts from the clients actual contributions with regard to the purchase and intention with regard to beneficial interest. I'm sure that you all have variations of co-ownership questionnaires, but if you look at Alan's version, it's quite useful on the basis that it gets to the heart of the matter. Hey, Mr. and Mrs. Client, or hey, clients, what are you contributing? And what's your intention with regard to beneficial interest? Co-ownership, as we'll see, is a happy hunting ground for claims against residential conveyancers and also complaints against residential conveyancers. And without sort of stealing my thunder a little later, in short, what happens is conveyancers tend to make assumptions about our husband and wife selling a property that they held as joint tenants, therefore they must be buying as joint tenants. Buy-to-let investor clients, no relationship between them, it must be a tenancy in common. Unequal contribution, it must be a tenancy in common. Assumptions are dangerous in residential conveyancing generally. They are extremely dangerous in the context of co-ownership, as we'll see. The first point to note, really, that I want to make today with regard to complaints and indeed claims is to make sure that we set realistic client expectation. And I've touched on this theme in the past, to be honest with you, and there are a number of sort of key questions I think we should look at, and a number of key points that I make. Firstly, just who is the client? Do we know the client? There are some clients that are more risk averse than others. There are some clients that get extremely stressed out with regard to the conveyancing process. And if that is the case, we've got to approach those clients differently to the sort of run-of-the-mill client. And again, it's important that we identify who the client is, what their expectations are, and what we can deliver to meet those expectations. The SRA and Law Society both highlight the fact that we should be looking out for stressed clients and trying to ensure that they have a more comfortable path during the conveyancing process. Now, I concede that's potentially impossible to achieve, but you get the point that I'm making. Just identify who the client is. Remember, there's no such thing as a collective client. And remember that clients will have expectations with regard to the conveyancing process that may be radically different from what you're intending to achieve. And it's important that our engagement letter, our communications with clients, make sure the clients understand what we're doing. And the first real point that I want to make this morning, what we're not going to do. If you look at your engagement letter and your communication, emails, etc. with clients, they'll be very impressive at telling clients what you're going to do. But they may not be impressive as to telling the client what you're not going to do. And it is important. So I mentioned in the notes, if we're acting for a buyer and the seller in the contract pack produces the TA forms, do we explain to the client how they use those forms? That in essence, if the seller makes an erroneous response or reply, that we potentially, our client potentially, can sue for misrepresentation. But is that realistic? Is our client, perhaps where he has a potential claim for £5,000 worth of misrepresentation, really going to embark on a county court action to try and recover that amount? Is he not, in fact, simply just going to write it off as a potential bad job and just take the hit? I always say, with regard to TA forms, if we're going to be realistic, the TA form should be used as a checklist so the client satisfies himself or herself or collectively as to the questions that are posed in those forms. Surveys. Do we tell the client the need for a survey? Yes. Do we advise the client to have a structural survey or the best survey they can afford? Yes. Knowing that the client is likely to have some form of valuation or rely on a lender's valuation, does the client understand the significance of that lesser report or survey? Again, the RICS Consumer Guide to Surveys and Valuations is a valuable aid to assist us with regard to setting realistic client expectation. Do we tell clients about the limitations relating to searches that we undertake? So does the client know that a local search is out of date the moment it's done and is property specific? And if we've got a client who is aware of that, the client may be willing to pay for indemnity insurance, etc., relating to a defective search, may be prepared to pay for additional searches, etc., in order to resolve the potential issues. We may have other clients that are quite happy and quite appreciative of the fact that there are limitations relating to the searches that we do. We've spoken in the past about the need to tell a client to inspect target property and what they should be looking for when they inspect. Do we tell clients, if we're obtaining an environmental search and report, that we're not going to be able to advise as part of the conveyancing process and as a transactional property lawyer about environmental or contamination issues? That if we get a report that reveals adverse entries relating to contamination, it will be necessary to get additional reports, and it may be necessary to instruct experts with regard to advice relating to those issues. We've already spoken in the past about title plans, and a client needs to be aware that they can't rely on a land registry title plan to identify the extent of the land that's being acquired. Leasehold transactions, I mentioned, we're going to get from the seller's conveyancer 3-year service charge accounts. But so what? Our job is to tell the client what the lease says, and I suppose what our job is to have a look at the service charge accounts to see the landlord is providing the services that he or she is compelled to do as per the lease. But I can't tell you whether a set of service charge accounts are good, bad, or indifferent. I can't tell you if the accounts have been produced in accordance with relevant accounting policies. Now, if my client is buying a £15 million flat in central London and the service charge is £56,000 a year, we might be looking at some fairly complex accounts relevant to that property. We've got to be advising our client about the need for accountancy advice relating to that documentation. Do we do so? So are you confident that your expectations as to what your role is are the same as your client? And is that the same throughout the transaction? So this idea about being realistic relating to clients, I think, is important. We've got to make sure that we're communicating with clients in a meaningful way. We've got to explain to clients, particularly where there are delays in the conveyancing process, why the delay has happened, and we've got to explain to the client and revise and review timescales in that connection. And we've got to understand and appreciate that our clients may have a lack of knowledge with regard to the conveyancing process. We talked about this when we talked about the problems associated with lockdown. You know, this may be a relatively new experience for a client, and therefore there's a degree of handholding relating to the client that I think is important. If you look at page 3 of the notes, I asked some basic questions. Do we always ask about client objective? You might get an obvious answer, we're buying it as a family home. You might get a surprise. Does the client understand what the conveyancing process involves and the limitations associated with it? So do you ask the client what they think they're selling or buying? And during the life of the transaction, very important point, do you ask the client if they understand the information that you've provided and whether they have any questions? No matter what the communication, email, orally, or whatever, imperative that we explain to our clients that it is for them to tell us that they don't understand, and them to tell us if there's something missing with regard to the information that's generated. We've talked in the past about informed consent, and in essence, that's the point that I'm touching on at pages 2 and 3 of the notes. There are some good habits with regard to the conveyancing process. So make sure you do what you say you're going to do. Make sure you follow up on outstanding issues. Make sure that you are clear and understand that the client understands what you're telling them and that you keep records. In the notes, I talk about the duty to explain at page 4. But just before I do that, I mention a number of external sources, some of which I've touched on already. Leasehold Advisory Service guides, Leasehold Knowledge Partnership guides. I mentioned Land Registry public guides, no longer available, no longer in circulation, but there were some very useful public guides that the Land Registry generated. Public Guide 17, dealing with property fraud. Public Guide 18, dealing with co-ownership, now available on the government website. So we can extract that information and produce it for clients or refer the clients to the source of information. Do you and have you read your firm's standard letters? Are they understandable? And do they meet the needs of the particular client that you're currently acting for? Are you providing clients with links to websites? And are clients communicating with fee earners in a manner that they can seek explanations or information from those fee earners? I talk about the duty to explain, and we've covered these cases, to be honest with you, when we looked at lockdown, but I'll just reiterate the fact that the SRA has reminded conveyancers to explain the fundamental difference between freehold and leasehold ownership, and that where we're dealing with leasehold transactions, we should not only be explaining the radical difference in ownership of the two, but also looking at leases and not just providing the client with a copy of the lease, but making sure the client understands what the lease is doing in connection with the generation of rights and obligations. Page 5 of the notes, I talk about county personnel and Pulver, which I've mentioned to you in the past, and Bellaghan Boys Sutton, which again I've mentioned to you, but to reiterate in the context of negligence claims and client complaints. Make sure that if you've got provision in a document that is vague or ambiguous, you explain to the client, this is what I think this provision means, but it's vague, it's ambiguous, and I could be wrong. Therefore, the only true test to determine what that provision actually means is litigation, and as far as that litigation is concerned, there is a risk and there is a significant cost. Be careful about advising clients who are risk averse. If we look at Dreamvar and Mishkondareya and some other cases around about the time of that case, courts were emphasizing, and the Court of Appeal was emphasizing, you might have a client that is particularly risk averse that may warrant either warning the client in even more detail about the risk or taking steps to deal with that risk. So later this morning, we're going to talk about property fraud and seller identity fraud. Well, of course, there's no way anyone can actually guarantee that the seller is who they say they are. There is always a risk of seller impersonation, as we saw in Dreambar and other cases. If we've got a particularly risk-averse client, then why not think about an indemnity policy to cover off that risk? And I'll be talking to Robert Kelley of Stewart Title a little later about a policy they've got for precisely that particular position. So as far as the duty to explain is concerned, the issue is really supportive of the concept of informed consent. A client can only consent to a particular course of action in a conveyancing transaction if they're fully informed and if they understand. So we've got a situation with regard to a defect in title. We can take out an indemnity policy. Does the client understand what that policy does and doesn't do? We've got a situation where we've given advice to a client that perhaps due to a defect in title or a problem with title, they ought not to be buying this property. Does the client understand why we're taking that view and that stance? Both of those things, this sort of explanation, this clarifying from the client that they understand or don't, will assist us with regard to complaints and potential claims at a later date. I concede that there'll be some clients that, no matter what you say, no matter what you do, will not understand. But it is imperative from a conveyancer's perspective that you have evidence on file that you've asked the question whether they understand or not, and they've told you that they do, and you've asked the client, do they have any questions, and they've told you that they don't. At least if at a later date there is a problem or issue, you've got some defense to a complaint or a potential claim about the client not understanding the process or not understanding the advice. So we've talked about the duty to explain in the past. Basically, the important thing is that we explain so that a client can understand as best as possible. I now want to talk about issues relating to searches and enquiries. And before I deal with TA forms at page 6 of the notes, I want to talk a little bit, if I can, about the use of searches and to highlight to you the fact that there isn't such a thing as usual searches in a conveyancing transaction. I'll be looking at this in more detail in page 12, but my starting point is that there isn't such a thing as usual searches. As far as searches are concerned, searches should be client-specific, property-specific, and transaction-specific. As far as inquiries are concerned, the conveyancing protocol requires us to utilize the standard TA forms. But again, as far as those forms are concerned, they may not be complete. There may be questions that our client wants us to ask of the seller's conveyancer, in which case I would always advocate you should be saying to a buyer client, we're going to raise or we're going to be provided with standard replies to standard inquiries. Are there any additional inquiries or questions that you would like to ask us to ask the other side about? And again, as far as surveys are concerned, important that the client understands the limitations relating to surveys and valuations that they choose. And we've talked about client inspection in the past as well. Remember, clients should be inspecting before exchange to identify state and condition of the property, to identify the existence of overriding interests, to identify the physical extent of the property, and also to check what the client sees on inspection is consistent with the information that's generated within the TA forms. Just want to go back a minute and just touch on the issue relating to TA forms. In the notes at page 7, 8, 9 onwards, I talk about the potential for misrepresentation and highlight the fact that there are a number of issues relating to the TA forms. Point number one, if we're acting for a seller, all we have to do quite simply is provide the TA forms to our client, ask the client to complete them as fully as possible, warn the client about the potential for misrepresentation if a response is defective, and if you've got an untrustworthy client, warn them about the potential for committing an offence under Section 2 of the Fraud Act if they lie with regard to a response. Our job as a conveyancer is then to check the TA form against the information that we have on our file to make sure the seller has said things that are consistent with what is revealed on our file. If what is said is inconsistent, we refer the client back to the question and say, look, you've got this wrong. This is what the title reveals. That question requires amendment. So from a seller's perspective, there isn't too much of an issue with regard to the use of the TA forms. It's a relatively simple task from the seller's conveyancer's perspective. But remember, it is the seller that completes the form. The cases that I've given you in the notes highlight the fact that the forms are being completed by a seller without advice. If a seller is leaning on us to provide advice with regard to the completion of the forms, then that potentially creates a hurdle where a misrepresentation claim subsequently follows. So it's better that the client is filling or completing or populating these forms with their own information. And our job is simply to check what the seller has said. From a buyer's perspective, with regard to the TA forms, the client should be told that the TA forms are a checklist that the client should be utilizing to satisfy themselves as to the state and condition of the property. So, if you look at page 12 of the notes, if acting for a seller, have you advised the client about the potential for misrepresentation if a response is defective? Have you advised the client of the need to advise you if any of the responses within the TA forms changes before exchange of contract? And have you advised the seller if the seller were to deliberately conceal an issue or lie about a response, then that constitutes a criminal offence under Section 2 of the Fraud Act. As far as Section 2 liability is concerned, a buyer does not have to be induced to enter into the contract for a criminal offence to be committed, and the buyer doesn't have to sustain any form of loss for a criminal sanction to follow. So, if you've got a client that you think is really dubious or dodgy and not taking the response with regard to the TA form seriously or not, then you could provide the client with a sort of health warning with regard to what they're doing. I talk about searches, and again, as I've mentioned before, really no such thing as usual searches, but we're lucky. We've got search providers that will tell us which searches are available. And what we should be doing is saying to our buyer client, these are the searches that are available to you. These are the searches that are essential. Are there any of the other searches that you'd like me to undertake on your behalf? Or are there any other issues that might warrant further investigations or searches that aren't listed? Because there might be something that's peculiar to the client's objective relating to acquisition, or unusual with regard to what the client is wanting to do, in which case we should be checking or identifying if there are searches available. I'd like now just to introduce Robert Kelley from Stewart Title. Robert's the business development manager. And Robert, again, as far as searches are concerned, I think it's useful to discuss with people attending today just what raft of product you've got available to practitioners relating to searches. So Robert, I don't know if you can hear me and if you're happy to join in, but this might be a useful spot just for you to explain what Stewart Title can do with regard to problems and issues associated with searches.
Yes, thanks, Ian. I mean, obviously, if you have a search and it reveals problems such as lack of plan permission, building regs, or environmental search revealing potential entries, then we can offer policies there to give protection against any problems that might arise from that. Your client may well be willing to take a view on planning and building regs, but then you may actually find that a lender wants more protection. So we do offer lender-only policies there to protect them. And really from a lawyer point of view, by getting a policy for these sorts of things, it does give you a property-specific recourse rather than it coming back and biting your professional indemnity policy later. So I think there is a market there. If you don't want to do searches, then obviously we have no search policies available, which cover all of the, well, as we say, there are no usual searches, but cover the main searches of the local authority search, local land charges, mines and minerals, and drainage. As you were saying about things varying from different property to property, our mines and minerals ones do actually cover all relevant mines and minerals in the area. So
Right.
you don't need to scratch your head to think whether you need to do a Cheshire brine search or a Cornish tin search. It's automatically covered there. So that again is a bit more protection for people there. And we're also now including specific highway searches in the cover as well, with new policies we're issuing there to get over another issue. So that is available there for people, depending on the nature of your client. If they're an investor, they may well be happy with it. If you're a residential buyer buying to live in a property, then you may actually want the full information. And as we come out of lockdown, then there may well be delays with local authorities providing full information. So there are search delay policies available. And also, if you've had a property that's been held up during the lockdown, you may actually come now and find that your searches, as you say, they're dead the day they're issued, but generally acceptable for 3 months. But you can get a search validation policy to extend the validity of that search for up to 2 years. So they're all available there really to help you in those circumstances.
Thanks, Robert. Robert, there's two issues that sort of flow from that I'd like to share with delegates if possible. First of all, you mentioned mines and minerals. Do be careful. I talk about client objective. And I had an email last week from someone whose client was telling the conveyancer that he was buying a property, and one of the first things he was going to do was construct a swimming pool. Well, again, you know, that immediately, to my mind, generates an issue, any form of subterranean activity. And again, you know, the thinking there is, well, we need to think about mines and minerals issue. And the other point is, I think, again, I was talking about the risk-averse client and knowing your client. So you act for someone who's really jumpy about the conveyancing process. Well, there are indemnity policies that can sort of sit behind the conveyancing process to provide the client with some comfort, of course, the lender with some comfort, and also some comfort for you on the basis that, you know, the jumpy client who is sort of very risk averse might be the sort of client that at the end of the transaction, when a problem arises, starts pointing the finger at you with regard to what you did or didn't do in the conveyancing process. So again, important, I think, to understand and appreciate the fact that there is indemnity cover sitting behind you to afford protection. I mentioned the notes at page 14, the issue of client inspection. And again, important that we tell our client to inspect before exchange, at exchange, before completion, and at completion. An interesting question, we're not putting this as a poll to the room, but I would sort of put it open to today. How many people would advise a residential buyer client to inspect target property at exchange of contract? If the property is empty, if the property is prone to vandalism, then there's an issue about the state and condition of the property at exchange. And of course, if you as a buyer don't have knowledge of state and condition at exchange, then if there's a material change in state and condition, the opportunity to potentially rescind the contract is lost. So if I was buying a property out of area, buying a property that was prone to vandalism, buying a property that was empty, I might be suggesting to a client to inspect. Now you're going to say that's impossible. Client lives in London, buying a property in Manchester. Are we really saying on the day of exchange, he goes up and has a wander around to check all is well? I appreciate from a practical perspective that might be difficult, if not impossible. My option in that situation is ask the agent to go and have a look and, you know, just record on a telephone what they see, so you have some evidence as to state and condition. Remember, we need to identify overriding interests, and our client should be inspecting at completion because he or she is under an obligation to notify the land registry of any overriding interest that exists at completion, and there is an obligation to complete Form DI as a consequence. I mentioned in the notes at 16 onwards issues associated with title. Before I do that, we've spoken in the past about title plans and the problem with plans. And I want to cover off this issue now if I can. Remember, a land registry title plan does not reveal a legal boundary, it reveals a general boundary. And remember what we said when we were together last time about determined boundary applications. I hope delegates that have had time have had a look at the process for determined boundary applications. It's not a particularly complex process, and where there's agreement between landowners, a determined boundary application is a very quick fix for resolving boundary issues. I mentioned, as far as the notes are concerned, at 17 and 18, issues relating to a good and marketable title. Remember, we are certifying to a lender that our title is good and marketable. A good title and a marketable title are not the same. And as far as a marketable title is concerned, in essence, what we're saying is that the seller's estate is supported by maximum evidence requirable by conveyancing practice and law, which suffers no blot to which a prudent buyer might object. In other words, there are no encumbrances, no defect in title which a buyer properly advised would object to and refuse to proceed with. In simple terms, you're establishing to the satisfaction of a buyer who's performing due diligence with regard to his purchase that the seller owns the property and it is as unencumbered as possible, save that which is revealed by the title that is produced. Practical steps to avoid claims relating to title: check the title guarantee in the contract, check what encumbrances are revealed in the contract. If the title is registered, what title is being offered. Remember, we might be able to upgrade a good leasehold title. Do watch leasehold titles that are granted post June 2006. You may see a warning in the property register that the land registry has not seen a consent required for a superior title. Nonetheless, the title will still be registered with an absolute title. And do watch unregistered land. If in doubt, ask the seller to voluntarily register the title. My sort of nightmare scenario that I've seen over the years: unregistered leases with an unregistered superior title. Frequently, as far as the lease is concerned, it will contain defects. The unregistered superior title may also have gaps or omissions, meaning that the land registry are likely to award a good leasehold title and nothing more, which may not be unsatisfactory for lending purposes. Other points to note, sorry, I'll just go back if I can. Page 18 and 19, I've talked about land registration issues. Watch notices that are placed on a title. A notice, as I mentioned last week, does not validate or legitimize a interest in land. It is simply a statement that someone claims to have an interest in land. Check easements and covenants. Again, just because they are noted on a title does not mean they are in fact enforceable. So again, they may impact on client objective. The position needs to be clarified. And as I've mentioned to you in the past, be careful about addresses for service, making sure clients are aware of the need to keep addresses for service up to date. If they don't, then they may lose the right of veto with regard to rectification. And in addition to that, they're going to generate vulnerableness relating to property fraud. I mentioned in the notes at page 20 issues with regard to defective title insurance. And again, Robert, rather than me sort of explain problems relating to policies, I think the best thing to do is to sort of highlight to delegates the fact that there are a raft of policies available relating to title, and that it is possible, rather than a standard policy, to approach Stewart Title for a bespoke policy if there is an issue associated with title. Could you elaborate on that for me, Robert, please?
Yes, I mean, that's right, Ian, that bespoke policies can be crafted really to cover whatever you need on there. But in many cases where there are defects in title, whether you're talking about restricted covenants or easements on there, there are standard policies online through Stewart Solution and then also
Yeah.
bespoke policies that can be designed for you to merge the risks. It falls in actually, of course, with the point you were making earlier about explaining to clients what you're doing, and with policies dealing with restricted covenants, for instance, it's important to advise the client that it doesn't get rid of the problem. If there are title defects and you're able to resolve them, you can do that. The problem is that's normally very time consuming and costly. So just make sure the client is well advised that this gives them financial comfort. It doesn't get rid of the problem that they may face in the future.
Yeah, great point, Robert. Yes, with regard to defective title insurance, I mentioned sort of two issues, and that's the first one. Clients, I don't know about your clients, but my clients over the years have very selective hearing. They love the bit that we've solved the problem, we've got a title indemnity policy in place to protect them. They don't hear the bit that the defect, the problem still exists. And the other thing that I think you've got to be cautious of relating to defective title is just explaining to clients, if the policy has a level of indemnity, why that level of indemnity has been chosen. I got caught out years ago in a commercial transaction where my client took out a defective title insurance policy, and the level of indemnity at the time was the value of the property that was being acquired. And we ended up with a claim that was worth significantly more than that. And these days, of course, there are policies and it's possible to increase the level of indemnity. But do warn a client in a residential context that the level of indemnity that is chosen may or may not accurately reflect the value of claim. Robert, again, if you can just come in here, I guess most of your policies will protect the client in that context, will they? In that they'll have an opportunity.
So yes, no, we do have, most of our standard policies have indexation at 10% per annum for the first 10 years. So effectively after 10 years, it's 200% of the level of cover there. So that is some protection there. You can always look, if you're buying a property and you've been offered a policy that the seller obtained, you can look to have that increased at completion. That's obviously something you should look at to make sure, as you say, that if you're offered an existing policy, that it reflects the current value of the property or the current risk to your client.
Good point. Yeah. On page 21 of the notes, I've given you some ideas relating to due diligence if there's a pre-existing policy. And again, do be careful with regard to that to make sure that if there is an existing policy, is it assignable? Does it meet your client's objective? And again, as Robert touches on, is the level of indemnity appropriate, given the fact the policy was taken out some time previous? So there's information relating to that at pages 21 and 22 of the notes. On slide, I talk about deadlines and timing. And the first point I want to talk about is exchanging contracts. A number of times I've dealt with client complaints and done training relating to client complaints. And one of the client's complaints has been, I was told that we exchanged contracts and a date was set for completion. On the day of completion, I had the removal van at the house. We were all set to move, and then completion didn't occur for whatever reason. And that sort of drifts me back to this point about setting realistic client expectation. If you've exchanged contracts today on a transaction, you as a conveyancer cannot guarantee that completion will take place a week on Friday. All things being equal, it will. The parties have contracted to complete on that date, and if they don't, they can be pursued for breach of contract, but you can't guarantee it. Therefore, what I suggest is you tell the client contracts have been exchanged, completion has been set for such and such a date, the parties are contractually obliged to complete on that date. A firm I do some training with has a list of what can go wrong between exchange and completion. It's sort of a completion day nightmare list. Now, not for the life of me suggesting that you do that and scare the living daylights out of your clients, but do you get the point that I'm making about making clients aware of the fact that there are potential problems associated with completion, rather than the client sort of drifting along between exchange and completion, thinking, well, completion is set in stone. And again, you know, the issues with regard to lockdown sort of heightened that, haven't they? And sort of revealed that, not just as a sort of an academic point, but as a sort of real practical issue. Other issues that can cause claims. At one stage, over 50% of negligence claims against residential conveyancers were as a result of either not doing searches or not advising clients about adverse entries relating to searches, or claims relating to a failure to register within priority. The number of those claims has reduced significantly, but they still do cause negligence claims. If you speak to any professional indemnity insurer about negligence claims relating to residential conveyancing, they'll say the same mantra that I say: do the simple things well. If we've got time limits, if we've got deadlines, make sure that we diarise not just the deadline, but a week before the deadline, so that we can react and deal with any problems or any issues that we've got in good time, rather than firefighting right at the 11th hour. On the issue of deadlines and timing, I'm a great believer, if you've got a paper file or an electronic case management system, of having an issues page. So anything that's happening during the life of the transaction, you note on your issues page on the basis that that's still outstanding. So we've got our local search, we've asked for a copy planning permission, we've got a copy planning permission, but there's 2 pages of the permission missing. I'd put on my issues page the fact that I'm still waiting for 2 pages of a planning permission. Therefore, if I get a telephone call from the client today saying, we've got to exchange contracts today, otherwise we're going to lose this property, there's a danger, because I'm busy, because I've got this instruction from the client to proceed with all haste, that I don't have time to flick through the file to see if there's anything outstanding. If I have an issues page, at every important stage in the conveyancing process, I can look at that and say, oh crikey, that's still outstanding, deal with it, chase it up, let the client be aware of the fact I'm still waiting for it, and that should potentially avert potential problems or issues. I want to explore now page 22 of the notes and to talk about co-ownership. As I've mentioned already, co-ownership is a happy hunting ground for claims in connection with the conveyancing process. It is important that our clients give us consent on the basis of information that we've produced to them. And as I've mentioned already, we've got to be careful about collective clients. There's no such thing as a collective client. I mentioned already to you the co-ownership questionnaire that was devised by Alan Tunkell. Well worth a look at if you haven't seen it. If you want a copy of it and you can't get it from Three Stone Buildings, if you send me a note, I'll send you a copy of it. Alan is quite happy for the legal profession to utilize it, and it sort of highlights some of the issues that I think are important. If we're giving advice relating to co-ownership, I think we've got to do a number of things. One, we've got to get our clients completing co-ownership questionnaires. If you are particularly cautious as a firm, it might be prudent to have each co-owner fill in their own questionnaire on the basis that there is a risk, if one form is filled in, that there is coercion or undue influence. My thinking there is, if there's a risk of that with regard to one form, surely there's the same risk with regard to individual clients filling their own forms in. So I don't necessarily hold that each client should complete their own, but I do think we should have a co-ownership questionnaire on our file. We should then ensure that we give advice to the clients relating to choices that they have, so they understand the choices that are available to them. And given the information with regard to the co-ownership questionnaire, we should be in a position to proffer some advice with regard to, given their circumstances, what is the best form of co-ownership. Flowing on from that, it is important that we explain to the clients the basics relating to co-ownership, and I'm not going to sort of drift on or talk about that today because time is obviously pushing on. But what I would say is, looking at this case of boycott against Williams in 2011 that I referred to at page 23 of the notes, if you are advising clients about the utilization of a joint tenancy, it is imperative that you tell the client that the joint tenancy can be severed, and where it is severed, a tenancy in common is created. You tell the client how a joint tenancy can be severed and the significance of severance. In this case of boycott against Williams, Mr. Boycott was close to being successful in a negligence claim against his conveyancers on the basis the conveyancer didn't explain to him the fact that the joint tenancy could be altered by his partner severing the joint tenancy and the significance of that. Mr. Boycott would have won his claim but for a limitation issue. I've given you notes confirming the Law Society Conveyancing Handbook, identifying some of the issues that we need to deal with regard to co-ownership. 2 points. First point I've mentioned, joint tenancy can be severed. I explain the significance of severance and method of severance. Tenancies in common, important point. Clients advise that if the beneficial interest alters, then the deed of trust needs to be reviewed and amended. I've dealt with a number of negligence claims over the years against conveyancers where the client has been advised about the creation of a tenancy in common, a deed of trust has been created, but the client not advised about the need to keep that deed of trust under review. If you've got a client that isn't willing to pay you with regard to a deed of trust, you can use Form JO, the Land Registry Form JO, although I wouldn't advocate it. And it is important where you are dealing with co-ownership and the conclusion of transactions that you advise the client where a tenancy in common is created, that that tenancy in common should be kept under review. I mentioned in the notes at 24, the Land Registry Public Guide 18, which was very useful indeed. Funny story to tell you about. I used to do some presentations for the Land Registry, and on one occasion I did, and I noticed someone at the back of the room that was beaming rather than falling asleep. And the reason that he was beaming was that I was waxing lyrically about Land Registry Public Guide 18 and how useful it was. And it transpired that this particular land registrar had created Public Guide 18. As a consequence of him being delighted with me, whenever I had any issues with that particular land registry, then whatever my view was or my stance was seemed to be accepted without any form of argument. So it does pay, doesn't it, that being nice to people can sometimes have very pleasing results. He's retired now, so I don't have that sort of hold over that particular land registry anymore. Make sure clients are aware of choice with regard to co-ownership and assume nothing really is the stance that I'm recommending and advocating. I'm now going to move along, if I can, because I'm conscious that I'm taking everyone's time up, and talk about land registration and fraud, page 28 of the notes. I just want to skip through towards the last slide, if I can. Number of points here. The Land Registry give guidance relating to property fraud. It used to be contained in Public Guide 17, it no longer is. The Land Registry do recommend restrictions being placed on a client's title, requiring you to certify that the person dealing with the land is indeed the registered proprietor. There are lots of firms that don't like the idea of that on the basis that it's generating potential problems with regard to verification of client identity. Remember to keep addresses for service up to date. And in the notes at 29, I've given you the case that's sort of sitting behind Dreamvar and Mishkondareya, Puran Singh. Interesting case concerning two firms of licensed conveyancers, both held equally liable for the buyer's loss as a consequence of seller identity fraud. Interestingly, the judge said that this was a high-risk transaction. One, it was a relatively high-value property. Well, most properties in London are. Two, the property wasn't subject to mortgage. Well, again, not that unusual in my book. Three, the bit that caused me to smile, the judge emphasised this was a high-risk transaction on the basis that the seller's conveyancer was pushing, the seller was pushing the seller's conveyancer to proceed swiftly with regard to the transaction. In other words, the seller was very impatient with regard to an exchange of contracts and completion. Now, I don't know about you, but in the vast number of years that I've dealt with conveyancing transactions, I've never had a client who said to me, Ian, just take your time. You know, if you want to go and play golf this afternoon, instead of exchanging contracts, you go and do that. So, you know, I think it's quite bizarre to say if a client is putting pressure on you to proceed with the transaction, you ought to be suspicious. But I think the point here was, the client was putting pressure on the seller's conveyancer, but not justifying why there was pressure to proceed with the transaction. Puran Singh highlights, with regard to identity fraud, the fact that you need to be vigilant throughout the transaction. It's not enough at the start of the transaction simply to go through your ID checks and then think nothing else thereafter. One, as we've talked about in the past, if land is registered and you're acting for a seller, is there a connection between the seller's addresses for service at the land registry and your client's own contact details that they've given you? Two, is the client familiar with the property, familiar with issues and problems associated with the property? Three, as far as the client is concerned, are they communicating in a normal manner? So if they're changing mobile numbers constantly, if you ring them and they don't answer the phone when you ring but then call you back, these are all things that are potentially suspicious and should justify further investigation. Do you check client signatures on documents? So you've got a contract, you've got an engagement letter, you've got a transfer. Would you check signatures to make sure that the client is who they say they are? Property fraud leads to negligence claims, because if a lender takes a hit with regard to being duped out of advance monies or being duped out of proceeds of sale, etc., then they will look to the conveyancers to recover loss, as well as the loss that the potential innocent buyer sustains to boot. So there's quite a bit of information in the notes relating to fraud. Robert, I did touch on the fact that you have a product relating to seller identity fraud, and I'm always amazed that a lot more firms don't use it, where they've got a sort of risk-averse client, or there are suspicions generated by client identity due diligence. So I wonder if you could share with delegates the details of that policy, please.
Yes, Ian. I mean, it came out of the initial decision in Dream VAR and then the Court of Appeal one, which really threw a totally unfair obligation on the buyer's solicitor to be able to identify the seller, which isn't possible in normal markets at all. And it occurred to me when we were talking about coming out of lockdown that actually it's probably going to be more risky now, isn't it? Because we're going to get used to doing things at distance. Are you going to meet your client face to face? We're probably still going to be advised to avoid those sorts of meetings. House viewings may well be done without the owners being there. So some of the trigger points before where you could identify fraud may have gone. So I think there's a greater risk now. What our policy does is it provides cover for the buyer and for the buyer's lender against seller fraud to the extent that you cannot identify. You have to rely upon the seller's solicitor. So it gives you protection there. Going back on some of the points in Persing and so on, we do cover unoccupied properties if there's a legal charge registered or if the restriction's been placed at the land registry. And whilst it is a very, very rare risk, it is, of course, probably the most devastating one you could suffer as a solicitor. Most of our policies, we're talking about a small diminution in market value. Here, you're talking about 100% or 90% if you've still got the deposit of your money disappearing, which would be a massive hit for any firm. And the great thing about the fraud policies is it gives you and your client a property-specific policy. The client doesn't need to prove negligence on your part, which they would need to do under the PI policy. So it is a much quicker process for the client and also removes that risk from your PI policy, which would no doubt reassure most conveyancers and probably particularly their non-conveyancing colleagues that the firm's got some protection there.
Yeah, good point. On the issue of property fraud, I'm often asked about, thanks for that, Robert, I'm often asked about should a buyer's conveyancer be asking warranties of the seller's conveyancer as to seller's ID? And my stance has always been, don't ask the question, because if you do, you're showing that it's an issue, and a seller's conveyancer is going to tell you, no, I'm not prepared to give any form of warranty other than to confirm I've done my appropriate AML checks. Therefore, sort of asking for warranties, I think, creates an additional problem for the buyer's conveyancer on the basis that the seller's conveyancer is not going to give you the warranty that you want. There's a brilliant paper written by a barrister called Nick Taggart called "Who Do You Think You're Kidding?" He's a massive Dad's Army fan. And he's written this article all about identity fraud. And it's very, very authoritative, goes through all the relevant case law and comes up with all sorts of practical advice. In short, confirming the point that I made, that as a buyer, don't ask for warranties from a seller's conveyancer unless you know you're going to get them. Because what you're doing is saying, hey, look, I'm aware there's a potential problem, but when you then don't get a solution to the problem, you've basically created a huge risk for your client that the client needs to be made aware of. Stewart's seller identity policy potentially cuts that potential problem off and deals with it. Steve, once again, I've talked too much and I've overdone my welcome and overrun, so I must apologize to you and indeed everyone else. But what I'd like to do is open up the room to questions, if I may, Steve. I think also, Steve, you had a poll, or you had some additional questions or things to speak to delegates about. I'm sorry for taking your time.
Not at all, Ian. No, thank you so much. I think we will we'll skip the poll, Ian, and there's been plenty of sort of chat in the background. Some questions emanating from that. A lot of caution, I think, about our earlier poll right at the start there, and coming out of lockdown, how this will work, whether we're ready. So there's a lot of chatter about that actually in the background, and you know, making sure that things are done in the right way, which we alluded to earlier before the webinar, Ian, about the sort of deep cleaning of houses, how the transaction happens. So a lot about that. We have got a couple of questions that I will bring up straight away, and as I say, it's open to the floor if anyone else has some more questions. So the first question I have here is from Mark Kens, and it refers to the fraud aspect here. So, should we be advising purchaser clients that we cannot 100% guarantee that the seller may not actually be the true owner of the property, i.e. maybe a...
Yeah, definitely, Steve, because you can't.
Yeah.
100% guarantee, definitely not. You know, the problem with property fraud is fraudsters are very, very clever. And, you know, when you look at what can be done and what has been done over the years, it's pretty scary. And, you know, no matter what checks, no matter what systems you put in place to avoid fraud, you know, fraudsters being what they are sort of one step ahead. So, you know, no way in a million years would I be able to be 100% confident. Now, yeah, if I'm acting for a seller, they may be clients that I've dealt with, you know, for 30, 40 years, and I can warrant or justify who they are. But, you know, from a buyer's perspective, can I give my buyer client that 100% of confidence? Answer, no.
Yeah, and I think as Robert alluded to, I think that's even harder in these times as well. So
definitely. Well, when conveyancers are busy and when times are unusual, then there's even more opportunity for fraudsters to do their worst, as it were.
Indeed, yes. We have another question slightly separate to that, but from Zara. Zara asked, do people send out the TA explanatory notes, the TA forms, by way of explanation, basically suggesting that some sellers are a bit clueless?
Well, they are, yeah, definitely. But case law suggests that a seller, the forms are created so that the seller fills the forms in isolation, without any advice or guidance from conveyancers. Now, I concede that you will get clients coming to see you saying, I don't understand what this question is, or emailing you or ringing you in the same vein. But technically, it is a form that the client fills in, and the client fills it in on the basis of information that they are aware of.
Yeah, okay, thank you, Ian. a follow-on question there as well, and that's how far should you go in educating the client as to the process, and also is it preferable to give them all the info in one hit or in stages /
Yeah,
report on different stages,
yeah.
e.g.
I
time
would
also?
report in stages. I would not be providing a client with a huge volume of documentation or one huge letter. What I'd be doing is providing it in a sort of piecemeal fashion as the transaction progresses. The use of a flow chart can be quite useful. Online flow charts with information links or information sheets, that works quite well. And then what you're doing is supporting your communication with the client with that sort of background of information. So, you know, flow chart showing this is the standard conveyancing process, and then at each stage a sort of information sheet. I've seen it done in sort of cartoon format, to be honest with you, Steve. And then an email or a letter sort of underpinning what is happening with regard to the transaction, but referencing to that flow chart and that ancillary information. I think one of the big things that to get over today is there's a wealth of additional information that we can utilize to support our clients during the conveyancing process. Leasehold advisory service being the obvious thing, yeah?
Yeah, no, absolutely. And I think the useful websites as well, that's within your notes that you provided, Ian. So
yeah.
That as well. Thank you. Just a couple more questions. I'm obviously conscious of time as well here.
Yeah.
So one from Robert McAnally.
Yes.
Robert asks, if it's not possible for a solicitor ever to confirm that a seller is the actual seller, then how can a solicitor ever confirm that the purchaser will obtain good and marketable title?
Well, again, that's an issue. There's an issue there. You know, 999 times out of 1,000, it isn't an issue. But when push comes to shove, it is an issue. If you look at Purensing in particular, the idea about being able to verify that this is a good and marketable title becomes difficult, if not impossible. Well, wrong. You can say it's a good and marketable title, but you can't say that your client is going to acquire a good and marketable title. That's the point, isn't it?
Yes, no, I think so. Yeah, absolutely. I think it's possibly a good time to point out that that there are good title policies out there in the market as well. Stewart Title does have the ability to write good title products. Stewart Plus is available. We don't have it on our online system, but it's something that on a bespoke basis we can certainly look at. I've always wondered with this market if it's a viable product. I think that you, as an insurer, you're taking on quite a bit of risk there with things like fraud, boundary disputes, as we've touched. But yeah, it's something we can certainly look at there. And just one final question then, I think, and then we'll close it. So from Sarah Edwards is, do you think that the recently amended Form TA13 now effectively provides a warranty by the seller's solicitor that the seller is a registered proprietor and or entitled to sell the property?
Yeah, it potentially does, yes, but of course it hasn't been tested in the courts yet, Steve.
Yeah, no, that's fair. Okay, thank you. Right, so that, I think we'll across there. I'd just like to say, as always, thank you to everyone that's attended. I mean, the numbers that we've had attend these sessions have been far beyond what we expected, and we're really pleased with the feedback we've got, and that you appear to be enjoying them. People do come back. That's always a good sign. We will be extending the series, hoping that we're going to keep it to a Wednesday morning. So all being well, we should be back next Wednesday, and there'll be some communication in between then as to the next webinars we'll be hosting. I think that's fair, is it, Ian?
I think it is, Steve. Yes, I've enjoyed it, and I'm delighted that we've been of use to the profession. And as I say, I'm delighted on behalf of the profession for the support that Stewart Title have generated. It's been really encouraging and really useful. So thank you.
Absolutely, and Ian, thank you as well. I mean, we've introduced at the start a lot, but Ian obviously has his own business IQ legal training, and it's been fantastic to work with Ian through this. We'll be doing a lot more with Ian, and obviously looking to move this a bit more in-house. People, sorry?
I'm blushing, Steve.
Indeed, yes. But at the same time, if anyone would like to contact Ian directly to sort anything out themselves, as I say, we will be looking to provide some in-house training. We got feedback that that was something that was popular as well, but very happy to try and organise that and help that transaction as well. So thank you again to everyone, and I look forward to seeing you at a future webinar, and we'll be in touch as to when and how they take place. So have a good day, everyone, and thanks again.